Welcome to the Law by Leo podcast.
Welcome to the Law by Leo podcast with the founder of Law by Leo, Alexander Leonowitz. In high compliance industries like cannabis, gaming, and peptides, the rules change daily. To grow in 2026, you need a legal strategy that moves as fast as your business. Alex is a premier transaction attorney for founders and investors across Michigan and Illinois. He specializes in navigating the regulatory maze so you can scale without jeopardizing your licenses. My name is Leanne Lyon, and today we're going to talk about receivership with a cannabis business. Hello, Alex.
Hi, Leanne. It's nice to see you again.
Nice to see you. So we talked just before this that receivership is special for cannabis industries. So what we're talking about today won't necessarily apply to all the different types of high compliance industries that I mentioned in the intro. Is that right?
That is very correct. Cannabis, with its federal illegality, creates a myriad of issues, and one of them is receiverships. So we're going to dive into that a little bit today.
So with that in mind, with the federal illegality, how do you handle conflicts between state legal cannabis operations and that situation?
Yeah, one important thing to remember, Leanne, is in cannabis or other federally illegal activities, the protection of bankruptcy isn't afforded. What I mean by that is you can't simply run into a bankruptcy court when your cannabis business doesn't work out and ask for forgiveness of debt, or ask the court to intervene and step in and judicially and efficiently administer a bankruptcy estate. So with federal illegality, you're not provided that protection. And what that means in real life is that creditors can continue to come after you for amounts that they claim are due and owing from your business. So without bankruptcy, the next and most popular that I'm seeing currently in the space is receiverships.
So what exactly is a receivership?
So a receivership, and I'll keep it high level and easy to understand at first, is more or less a court-appointed individual or company that comes in, generally takes over a business, and efficiently determines whether to keep that business or sell the assets, but is ultimately doing it for the benefit of the creditors. So more or less the business owner or a creditor has demonstrated to a court, and it's a very high standard. Receiverships aren't easily granted. They traditionally are one of the hardest legal remedies to get. Now we see them more and more because of cannabis and the rise of cannabis. So we see receiverships a lot more happening. However, it's a very high burden to demonstrate to the court that a company should come in, take over a business for the benefit of the creditors, and determine how to administer that estate to provide some sort of monetary or some sort of contribution back to those people that are owed money.
So there's several different players from what I understand: receivers, creditors, owners, investors. How does all of this play into what you're talking about?
So those are all great and key terms that you need to understand in a receivership. So the first is the actual receiver. Okay. Mm-hmm. That's the individual or the company that is now in charge of the company. So they call the shots as determined by the court and outlined in the court's order. And that means who gets paid, what employees stay, what businesses they keep, whether they liquidate down the assets. That all goes to the receiver. So think of him of like the king of the top of the hill now. You replace the CEO typically with the receiver, and the receiver runs. The creditor is someone that is owed money from this business, which is now under a receivership. So in some instances, it is usually the first secured party which asks for a receivership. And typically in cannabis, that's either landlords or some of the financial institutions which go to the court and ask to say, we are owed money. We would like a receiver put in place to take this business over and ultimately determine whether we keep it or liquidate it down. And then you've got the remainder of unsecured creditors, or people that are generally owed money from this creditor or the company, but whose rights aren't secured in the same way that the first secured party is. So typically you see a UCC-1 statement filed, you see a lien against all of the assets, and all of that's papered up in documents. That's usually the first secured creditor. And then you have unsecured creditors, which are people just that do not have those filings but are otherwise owed money from the company.
Does that kind of create a race to be the first to request a receivership?
It does. It does amongst secured parties. I've seen situations where parties have scrambled to see who can get to the courtroom first to get their receiver appointed. And then it also becomes a battle in the secondary portion when it comes to distributing the assets of the business. So if you take a business and you sell it for $100 million, who gets that? And in what order and in what priority? And there's often a lot of litigation and a lot of dispute about who's owed what. There is a typical process that gets followed in an order, a pecking order, if you will. But there are times in which most of the time there's generally not enough funds left over when the business is sold to pay everyone. So it's one thing when there's enough money to pay everyone, but who gets paid first? But it's an entirely different thing when the pot gets a little smaller, and then you got to figure out how to carve that up.
So what about the owner, the investors, the people who started with a big dream that clearly has not worked out? Do they just walk away?
More or less. Unfortunately, that is a effect of receivership. It's typically the owners or people that had equity in the business that will end up with most likely little to no sort of payout from there. And it's because the individual or the company that initiated the receivership typically does so because they have a first priority lien, just like on your house with a mortgage. The first person to get paid is the bank. It's not going to be you as the homeowner. So it's a similar type situation in cannabis with cannabis companies.
So may I ask, how many cannabis-related receiverships have you handled, and what exactly is your role, as an attorney?
I've been on all sides of the receivership. So I've been the creditor, the one looking for the money from the company and battling with the receiver. I've been the one representing the receiver and hearing from all the creditors about where's the money, how's this coming in, when can I expect to be paid. So it's a relatively new phenomenon in terms of cannabis. However, receiverships have been around for a long time. One thing that's interesting, Leanne, is there's not a ton of, I want to say, precedence or guidance when it comes to receivership. It's a little bit more about the king that gets put in place, and more or less they're acting as an extension of the court. So there's a lot of latitude that gets given to receivers as they work through the company. And so that part to me is a little fascinating, is someone comes in, takes over, calls the shots. They ultimately do have to answer to the court. However, how they do it, how they choose to do it is largely within their discretion.
So that, again, sounds like a pretty clear contrast to bankruptcy, where it's fairly laid out. It will happen this way. The timeline is more or less known. Or am I hallucinating? Oops.
Nice play on words. And no, you're spot on. The bankruptcy as a contrast, and it's a lot of courts often look to bankruptcy when determining receivership issues. The bankruptcy code and how those get administered is much more thorough, thought out, methodical, whereas receiverships are a little bit on the other side of the spectrum, where it's a little bit more wide open, and so you get to see a wild different array of results, and especially in an industry like cannabis, which attracts a lot of interesting people. Combine that with receiverships, and you have a fun job every day coming into work.
I'm going to say interesting. Do you have, without naming any names, could you share any stories of a receivership that you've been part of that really did end well enough?
Yeah, I would say typically, well, let me give you an example. Okay, we've worked on, there's one in Michigan today that's a receivership. It's a fairly large estate, and they owed a lot of money to a lot of different creditors. And the reason I look at it more of a success, Leanne, than some of the others is because it's actually going to continue to exist as a company. The majority of the employees are going to stay there. The majority of the employees are going to keep their job. That business, although under a different name, will continue to exist and go forward. What I typically see, and is a bit more unfortunate, is I see a lot of liquidation of cannabis companies through the receivership. Most often they get in, they try to get as much money as they can for the assets, and most people are out of a job. The owners are out of everything. And that company ceases to exist entirely. This one I find and call it a success because it'll more or less still be there, although under a different brand and name.
So when it changes brand and name, what about the owner in that case? Can they still stay part of it or no?
There's nothing prohibiting that. And in receiverships, we've seen both. We've seen new owners or people that buy the assets bring on old management to help run it. After all, they know the business, they know the industry, so there's value there. And in other instances, we've seen the opposite, where the owners, for some reason, have gotten themselves into this situation, so they might not be the best person to bring back and run it again. So we've seen both options.
So if somebody is starting to think they might be subject to a receivership, what would you tell them to do? What steps could they take to perhaps avoid it?
In terms of avoiding it, again, you need to remember that is an extreme remedy. So courts and property law, if you're familiar, we really give a lot of deference to business judgment rule, give a lot of deference to businesses, and courts are often reluctant to stick their nose into somebody else's business and tell them whether they're running it correctly or incorrectly. So the first thing is it's an extreme remedy, and it's not often granted. On the flip side of it, I would often, and I've told clients this, is it feels very scary at first. When people hear receiverships, whether they're creditors or business owners or investors, they associate it with bankruptcy. The thing's done, I'm losing it all. In reality, there's always different paths and things that get carved out. So you can find your way back into those. It doesn't mean you're gone. But when you contrast that with where the business is going and what it was going to end up as, it can often be utilized as a vehicle to clear off old debts. It stays litigation. And Leanne, what I mean by that is you can't sue that business while it's under a receivership. So you owe me money, you can't sue me. Yet the receivership can go out and sue you. So if you didn't pay me, Leanne, I get to come after you, but you can't sue me back. So it's a bit fascinating that way. It's almost a shield and a sword being used at the same time.
Now, you practice in two different states, Michigan and Illinois. Is there a difference between those states?
There is. I think what's interesting with Illinois is that they have began this year looking a little bit more favorably at what's called an assignment for the benefit of creditors. Okay, and what that is more or less taking the keys and giving them to a third party to then administer and liquidate down the assets. That's different than a court order receivership in which the court stays heavily involved in a assignment for the benefit of creditors. You're essentially assigning that asset to someone to then sell and strictly liquidate down. So you see those a lot more in Illinois. You're seeing receiverships far more in Michigan because of the number of licenses that were given out. So I think the last count had over 1,000, maybe even 1,100 dispensaries that have been issued. Contrast that with Illinois, which is less than half. So it's a much healthier marketplace in terms of price per pound. Running and maintaining the businesses seems to be a little bit easier than it would in Michigan, which is more or less an open license state. So the contrast, Leanne, between the two is far more receiverships in Michigan than Illinois, and then different vehicles you're seeing some of these companies utilize when their business ultimately doesn't make it.
Which ultimately is why it's really smart to work with somebody who knows the local legal laws. Say that 10 times fast. So all of that points to why it's so critical in a new niche, in a new area where everything is changing frequently, why you really want to work with somebody who's local and who really knows what's going on. Anything you want to add to this as we're wrapping up today's episode?
I would say I've been both. So I've been the attorney, I've been the business owner. When it comes to receiverships, you really need both. You need an attorney that understands the legal parameters, what you can and can't do under receiverships and how they work. But you also need a business-minded individual as well. Again, this is an extension of the court coming in, taking over the business, and you need someone that can actually understand cannabis businesses inside and out. So for someone like myself, who's actually owned, operated, been in the space, this is something we do quite frequently, quite regularly, and we're always happy to assist and answer questions if folks have those.
Excellent. Well, thank you. And thanks to the audience for listening to the Law by Leo podcast. In 2026, the right legal strategy is not just about protection, it's also about growth. If you enjoyed the show, please like, share, and subscribe so you catch every episode. And to streamline your compliance and secure your next big move, visit Alex and his team at lawbyleo.com. And we'll see you next time. Thank you, Alex.
Thanks, Leanne.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.